All right, everybody, let's go ahead and get started. We have a pretty full docket. So good afternoon. My name is Don Nguyen. I am a Florida Bar Licensed Attorney specially appointed by the City of Titusville to serve as the magistrate for today's code enforcement hearings. These public hearings are quasi-judicial in nature. While formal rules of evidence do not apply, fundamental due process will be observed. Everyone with a case today will have the opportunity to present testimony. You may also present evidence or call witnesses to testify on your behalf. Please note that there is no public comment portion during code enforcement hearings. To speak on a specific case, you must either be the respondent or a witness called to testify. Everything said today will be recorded. All testimony will be given under oath. When you are sworn in, please state your name and provide your current mailing address so we have an updated record for sending any orders. The city will present its case first. Information may be displayed on the screens, and documents may be provided by the city as evidence. The city's PowerPoint presentation will also be entered into evidence unless there are any objections. After all evidence and testimony have been presented, I will make a ruling. My ruling will be reduced to writing and mailed to you. At this time, I will swear in all witnesses. If you intend to testify for your case, please stand and raise your right hand. Do you swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth? All right, thank you. You may be seated. All right, we're going to first take a look at the minutes from the prior hearing date, which was January 13, 2025, and provided to me from Tasha. I see no issues, so I'm going to approve them as presented.
I'm sorry.
No, I didn't know if you were bringing me something. Okay. All right, let's go ahead and go into the docket. We're going to start with the lien reduction hearing. It is case number 23-60. That is, I'm sorry, I'm looking at the wrong one. Sorry, I'm looking at last ones. We're 24-72. It is for the property at 195 Roosevelt Street in Titusville, Florida.
Yes, sir. This is a lien reduction request, and I have to present to you the lien reduction application.
Thank you.
Okay. The respondent, Matthew Myers, the violation address is 195 Roosevelt Avenue. The mail to address was 857 Westport Drive, Rockledge. And the violation at the time was for a dead tree. This case was originally heard on June 10th, 2024. The respondent at the time, James Carna, did not attend the meeting. The respondent was given until July 5th, 2024 to correct the violations on the property. A Massey hearing was held on July 7th, 2024. Testimony was presented at the city showing the respondent failed to correct the violation on or before July 5th as required. The respondent did not attend the meeting. Fines were imposed the amount of $100 per day starting on July 5th with the administrative cost of $216.58. On November 14th, the property was placed into compliance by code enforcement. The outstanding daily fine was calculated to be a total of $13,100. On November 26th, the Code Enforcement Department received an application for lien reduction from the current owner of 195 Roosevelt, which is Matthew Myers. The application, they're presented in accordance with Titusville Code for the special magistrate consideration. Mr. Myers purchased the property through a quick claim deed on June 7th, 2024. He advised, when I talked to him on the phone, he was not made aware of the previous owner of the code magistrate case on this. The respondent was requesting a reduction in the amount of $13,000. These are the dead trees that were on the property at the time. There's another picture of the dead trees. And these are the updated pictures. The trees and everything's have been removed, and there's no violations on that property currently. It's a vacant lot that had issues, but he's been maintaining it with no problem since he's purchased it.
Did he, when's the last time you spoke with him?
Like week and a half ago, and I informed him of today's hearing.
Did he explain the length of time between July and November it took him to bring it into compliance?
He said he just wanted to, well, he did make it was probably in compliance before that. That's when we officially closed it out, but when we received that information.
There's no one out in the hallway? He's not here?
No, sir.
Well, honestly, I'm kind of disinclined to offer any reduction. The reason being that the only reason that he gave was that he was not notified. As you pointed out in your presentation, he acquired it by quitclaim deed. When you acquire by quitclaim deed, you're taking that risk on yourself as opposed to obtaining a warranty deed and going through a traditional closing process. So saying that you weren't notified, that was literally the risk you took on. And without any other circumstances or any explanation from him, any other reasons or rationale why it should be reduced, I personally don't see any reason to be reduced unless the city recommends it in any way, shape, or form.
Like I said, he's not here, and yeah,
All right.
and he was notified. He also, the voicemail I got also confirmed today's date, so.
All right, well, I'm ready to make my ruling. I've reviewed the lien reduction application and the city code provision as applicable and have considered documentary evidence, including photos and sworn testimony relating to this matter from city staff and respondent. I will recommend the city council reject the lien application based upon several of the factors, primarily actions and the length of time it took to bring the property into compliance, the fact that it was purchased via quitclaim deed, and the only stated reason for the request was that he was not notified, but sort of the risk when you acquire any property by quitclaim deed. I have no other information about any financial hardship or any other mitigating circumstances. So and the lien will stand in the amount which was assessed, I think it was $13,100 plus costs.
$13,100 plus costs, yes.
So it is so ordered. I will recommend to the city council to reject the lien reduction application.
Very good.
Thank you. All right, we're going to move on to the Massey hearing. There's only one. It's 24-86. Officer Jim. Officer Flanagan. Sorry about that.
Nope, you're good. This is actually 3452 South Hopkins Avenue. That property was placed in compliance. They achieved all compliance issues for that, so at this time, there's no fines recommended at this time. And they've already paid for the administrative costs, so I'm just requesting an order closing the case. Is that correct?
Sounds good. It'll be so ordered. Thank you.
Yes, sir, if we could just get the written order that it's in compliance.
All right, sounds good. All right. Okay, we'll move ahead now to the initial hearings portion. The first one that's up is 25-09. Officer Flanagan, you are still up.
I'm still here, sir. As I said, case number 2409 for 1121 Second Avenue.
2509, yes.
I'm sorry, yes. I have an affidavit of hearing, an affidavit of notice of violation, and the cost recovery for $216.58 to present to you.
Did you want this back? Did you want this back? Are we okay?
Yeah.
Oh. All right. You may proceed whenever.
Yep. The respondent on this one is Emma Portlock. It's actually the estate of the owner is deceased for several years. The violation address is 1121 Second Avenue, Titusville, Florida. The mail-to address was the same. We have issues with 302.3 sidewalks and driveways, 302.4 overgrowth of weeds, 304.13.2 the openable windows, and 304.7 roof and drainage. These are all out of the IPMC. On May 16, 2024, a notice of violation was posted on the property. Date given to comply was June 16, 2024. Notice for respondent was mailed first class and certified on May 16th as well. Notice of hearing was posted at the property and City Hall on January 27, 2025, and it was mailed first class and certified on January 7th, 2025. During proactive neighborhood checks, I observed several issues with this property. Sidewalks were covered with debris and overgrowth of grass and weeds, overgrowth of grass and weeds throughout the property. Windows are all boarded up without access to egress, and the roof is damaged and requires repair. And currently there is people living at the property. The owner of the property, again, has died several years ago, and there has been no ownership legal change of the property. Still listed under her name. These are the original photos of the debris covering the sidewalk and the overgrowth of the sidewalk on both sides. That's just another angle of the sidewalk, and you can see the windows as well are covered up with boards. Just a closer shot of the boards covering up the windows and some of the roof damage. Those are tires up on the roof holding a tarp down. This is the north side of the property. You have tarps and different issues and damage to the roof along with windows that are covered up. This is just more debris that's on the property. And these are the follow-up photos from January 27th when I posted the property. The roof still hasn't been repaired. You can see the windows are still covered as well. More debris is covering the sidewalk in the front and debris on the side as well. And you can see the overgrowth for the entire property still needs to be cut and maintained. And that's also on the north side of the property where you can see it needs to be cut and maintained. And then on the back side, good picture of the roof. The windows are still boarded up. Sidewalks, conclusion of facts, the sidewalks are covered with debris and overgrowth of the grass and weeds. The entire property is overgrown with grass and weeds over 12 inches high. There's no openable windows anywhere on the property. They're all boarded up. And the roof and drainage, roof and siding is rotted. The roof has tarps and tires holding the tarps down and obvious signs of decay. The recommendation for the sidewalks and driveway to remove all the debris and overgrowth from the sidewalk. The overgrowth, cut the grass and maintain the grass and weeds throughout the property. To make the openable windows, remove all the blockage of the windows and confirm that all the windows work properly as required. And roof and drainage, repair and replace roof and damaged soffits to code and obtain permits as required. Okay. Ordered respondent to pay the administrative cost of $216.58. If the respondent or the state does not comply by April 11th, it is being requested that a fine of $100 per day for each violation be imposed until the violations are corrected, and to notify me for a reinspection upon compliance.
Property is vacant, pretty clear, right?
No, there's people living in
There's
the
people
property.
living in
There's
there.
people living in the house, yeah. I tried contacting them. We've had several other issues at that property, and these are the violations we're here to discuss today.
We have no indication or would have no way of knowing whether it's squatters or heirs or anything like that.
Last I heard, and it was years ago, that there was a relative living there, but currently I do not know who's living there.
Well, not much to say here. All right. All right. I'm ready to make my ruling on this one. I've accepted and considered documentary evidence, including photos and sworn testimony relating to this matter from city staff. I find that the respondent, the estate of Emma B. Portlock, is the owner of the property with the address of 1121 2nd Avenue, Titusville, Florida, 32780. I find that all required notices were provided in accordance with Chapter 163 Florida statutes and city code, and notice was met for this hearing. I find that there are several ongoing violations of city code, including all of sections 6-109, section 102.2, section for maintenance, section 302.3 regarding sidewalks and driveways, section 302.4, overgrowth of weeds, section 304.13.2, openable windows, and section 304.7 for roof damage and drainage. All such violations exist upon the property, and respondents were given a reasonable amount of time to correct the violations prior to the hearing, but either failed or refused to do so. Based on the evidence presented, including photos and evidence from the code enforcement officer, the violations continue to be in existence. The corrective actions for these violations shall be to remove the debris from the sidewalks, cut and maintain all the grass and overgrown weeds, removing all blockings and installing proper working windows, and to repair the roof and the soffits. Additionally, I find that the city has incurred costs in the amount of, where are we at? The slide. Sorry. In the amount of $216.58. Such amounts shall be included with this order. Respondent shall be given until, what date was it that you proposed? It was April?
2 months, April 11th.
April 11th, 2025, to correct the violations. Respondent shall be responsible for notifying the code enforcement officer of completion of such corrections, who shall then confirm the status of the violation. If respondent fails to correct the violation by April 11th, 2025, a fine will be entered in the amount of $100 per day until the violation comes into compliance. Further and future violations of the same sections shall be classified as a repeat violation. A certified order may be recorded in the public records of Brevard County. It is so ordered. All right, give me 1 second. Let me jot this down. Okay, I am ready to move on to the next item. I know the agenda was updated. We had a few that ended up complying. Do I need to read them out to the?
No, sir. We
Okay.
can go, I just didn't have time to remove them.
No, you're fine, you're fine. Is the next one 25-15 at 1245 Grumman Place?
No, sir, 25-11.
Only the second violation is in compliance.
Oh, I'm sorry, okay.
And it should be noted that the respondents are present.
Okay. I was trying to avoid Officer May Wright if possible, but I guess I'll have to deal with this. All right, 25-11.
All right, so I have 3 items to submit. First item is the affidavit for the notice of hearing. The second is the affidavit for notice of violation. And the third is the cost recovery statement in the amount of $234.19.
Thank you.
So once again, this is the initial hearing for case number 25-11. Our respondent is TPK Investments, LLC. Darlene Tyndall is the registered agent, and she is here this afternoon. Our violation address is 2671 Susanna Lane. Our mailing address was 2700 LaGrange Road in Titusville, Florida. Our violation is of section 34-10, site permit required. So the initial inspection was completed on May 10th of 2024. They were given until May 10th, 2024 was the initial inspection. May 24th, 2024 was the original compliance date for overgrowth. And then for the site plan was August 10th, 2024. Certified and first-class mail was sent to the listed owner and registered agent on the same day, May 10th. Notice of hearings were posted on the property and at City Hall January 28th and were mailed to the respondent on January 7th of 2025. So The violation of section 34-10 for site plan required was initially brought under in front of the special magistrate under case number 23-18 in April of 23. This was in reference to fill dirt placed on the property without permit. The respondent, TPK Investments, and Darlene Tyndall were present and testified. So initially, the respondent was ordered to correct the violation on or before June 9th, 2023, and with a $100 per day violation amount if she did not correct it. The respondent was also assessed administrative costs in the amount of $163.75. So at the June 2023 special magistrate hearing, the registered agent was in attendance, but the case was tabled to the July 10th, 2023 hearing. At said Massey hearing, the registered agent again was in attendance and testified she had submitted an application for new construction on June 16th, and it was under review. In addition, a variance was needed to address several of the review comments she had received. Oh, sorry. All right, I do apologize. So during the July 10, 2023 Massey hearing, I did confirm the application was submitted and that ground cover had been reestablished on the lot. The property at that time was placed into compliance by the magistrate and no fines were imposed. The administrative costs were paid in January of 2024. So for the current violations, I was completing inspections in the area and observed overgrowth of grass and weeds over 12 inches on the property. Photos were taken for the file. Reviewing my old case, I found that the variance for the permit had been denied back in September 2023, and the residential new construction permit from 2023 was found canceled due to no response for more than 6 months. The notice of violation was posted at the property and mailed. So, per our building department records, May 20th of 2024, a new residential construction permit was submitted, and review comments were emailed back to the respondent on May 22nd of 2024. At this time, there's been no responses submitted to those review comments, and the fill dirt remains on the property. The violation for the overgrowth was confirmed, corrected when I posted the notice of hearing on January 28th, 2025. So I have spoken with the registered agent, Darlene Tyndall, on several occasions. Back in July of last year, we talked about the overgrowth and regular maintenance, and then finding out what was going on with the building permit. At that time, she did not have a time frame for resubmitting for the comments. I did attempt to make contact with her in August and November of last year with no response. So on January 23rd, Ms. Tyndall did contact our department concerning the notice of hearing. She explained that the property was under contract to be sold, and that's why the permit did not move forward. So 34-10 requires a permit to be issued anytime there's any alterations done on the property, including clearing, grubbing, grading, excavation, etc. So these are pictures from the original case in 2023, showing the activities of the fill dirt being brought onto the property. And this is from the violation, the date I posted the notice of violation, May 10th of 2024, showing overgrowth on the property. And these pictures are from January 28th, 2025, when I posted the property and the notice of hearing, showing the overgrowth has been cut back on all sides. So conclusions of fact for the case for section 34-10, site permit required. The fill dirt remains on the lot without any approval, and there are no active permit applications on file for the property at this time. So for recommendations, we are requesting the respondent be ordered to correct the violation on or before April 11th of 2025. To come into compliance, either obtain the required permit for the placement of the fill dirt or remove the fill dirt from the property and reestablish ground cover on all affected areas. We ask that the respondent be assessed administrative fees in the amount of $234.19. And if the respondent does not comply by noon on or before April 11th, that a fine of $100 per day be imposed for each day the violation continues. And once compliance is obtained, to contact code enforcement.
Great, thank you. And the respondent is present?
Yes.
You may come just, to the podium and go ahead and state your full name and your mailing address.
Darlene Tyndall, 2700 LaGrange Road, Titusville, Florida, 32796.
All right, Ms. Tyndall, what do you have to say in response to what the city has set forth?
I had told her back in the summer or whatever after the comments that I had to take somebody to help me get through the stuff to get the permit finished. They did not end up doing that. I had contacted them several times about doing it, and they were like, oh, we're busy right now, we'll get to it when we get to it. And then they never did anything. And then in the meantime, I had somebody that, like we discussed, started talking about purchasing the property. So we went under a contract for that the first week of December. And then once the hearing came up, then they said they were going to move forward, which was around January 28th when she was talking about. But then now, the following week, well, actually the week before that, they said they'd move forward. Then the next week, right before our closing, they decided to cancel because they didn't feel like they would have enough time to get a permit pulled if they purchased the property. So right now, we're kind of in limbo. They say they might still want to move forward, but they want to know that they're going to have ample time to pull a permit, which they're not going to feel like April 11th is ample time. But I also, in case they do back out, have tried to move forward on submitting a permit, but I can't because at this point I have to get the plans recertified and stuff because the codes have changed to the 8th edition instead of the 7th edition, which I didn't realize that was one of the problems from the previous thing because, like I said, I did not understand some of the stuff in the letter. That's why I enlisted help. So
When you say...
either I have to get an engineer to recertify the plans and stuff to be able to move forward, which I probably still am not going to be able to get done by April 11th, or these people are going to purchase it and they're going to be doing that. So
When you say they were supposed to do it and they didn't do it, are you talking about the contractors?
I enlisted somebody. So I have a friend that's a contractor, but he's leaving me to pull the permit. So I'm like stuck doing everything myself. So some of the stuff I do not understand. So I enlisted another contractor to actually help me that has a permit person to pull it for me.
But in the year or so that has passed, I understand that a permit was applied for, and
was.
you or whoever was doing it on your behalf was given review comments that they never responded to? Or is that something you were aware
I
of?
got them, and then I gave the review comments to them, because when I saw the list, I was like, okay, now the list is getting bigger. So I was asking somebody to help me get the list done, but they just never did anything with it. But then I kind of stopped working on it because I thought that the property was going to be sold and I wouldn't need to pull the permit. The new buyers would be responsible for pulling the permit.
And just to clarify, the permit expired in the meantime.
Yes.
The application?
Yeah.
Right.
Which I also didn't realize that it had been that long. So
How long do you think it would take you at this point to submit a new permit application?
I don't know, because I asked the engineer how long it would take before he could get the permits back for me and resealed, and his answer was, I don't know. So I'm guessing more than just a couple months.
There was also I think the officer, May Wright, had talked about the possibility of removing the fill dirt. Is that not an option?
Really, it's not, because I mean, first of all, you're not gonna know what was there and what was not there, and at this point, grass has already grown over it. I mean, it's not something that's causing any harm to anybody else, it's just dirt on the property, and it's leveled even with the rest of the property. It's not like there's piles of dirt or anything like she showed, it just looks like a lot with trees. And except for the dirt, there wasn't anything really I did that was in violation.
As far as the buyer, what's their position right now? So if you're officially out of contract.
Yes, we're officially out of contract. They are on vacation, and they said they wanted to know what the results of the hearing was going to be today before they knew whether they wanted to proceed, which I know that they want more than a couple of months to do it. So I asked them how long that they felt like they needed from their contractor, and they couldn't give me they never gave me an answer on that either. But
Is there anything else the city would like to add, or?
I'm just curious if the plan is still proposed to include the potential buyer potentially getting a permit?
yes.
When will you be making that determination?
Once this hearing's over, if they hear that I only have 30 days or 60 days to get it done, they're probably not going to proceed forward. If they have probably like 6 months to do it, then they probably would. They just didn't want to feel rushed.
So just to clarify with May Wright, if I may ask her just one question, to get the permit issued would put the violation in compliance, correct?
Correct. If the building permit was issued, the site plan and that fill dirt would be a part of that permit.
And do you have any idea how long the issuance upon submittal is currently taking the building department?
No, ma'am, I don't.
Okay. I think that in order to, follow up with the prior cases, that 2 months is appropriate for the recommendation from staff on the compliance date.
Right. I don't like the idea of kicking it down the road and giving like 6 months or something like that, because there's no promise even now that you're going to be able to close. And that's not, that has nothing to, there's just factors beyond your control as far as, them purchasing the property.
Magistrate. If I could interject, I have a suggestion for a condition that could be proposed where a application for a permit be a condition of the proposed order, where maybe within the next 1 month that a application be submitted by either the respondent or the proposed, whoever is someone.
Yeah.
And then if that's not done, then the fines could begin upon that. But then that would also require the further compliance of the actual permit being issued subsequent to the application, which would be another set period of time, maybe 2 months from 1 month after the application being confirmed. Those are just some thoughts.
Yeah, and just thinking out loud, the issue is what I wouldn't want is not, give me 1 second. Let me finish my train of thought. What I wouldn't want is, for instance, the same process to happen again where an application is submitted and no follow-up, whether it be you or the potential buyer we're talking about, where now we're back in the same position. We're having another hearing again on the same topic. And so, but anyway, yes, ma'am.
Well, without the certified plans, I can't submit another application. I already went and had a meeting with Steve Adams, which is the head of the
The
building,
building official.
on Friday, and he won't accept any paperwork from me. And so until I can get the stuff from the engineer, I couldn't even move forward. And it's going to be 2 or 3 months before I can even get that from them. And then I still got to get the trusses place to recertify, and then I have to still get the AC people to recertify. There's just no way I'm going to get it done by April 11th, even for myself.
Right. But again, you understand this isn't a brand new thing. This has been ongoing for a while.
I understand that, but I also have not had the money to build the house. So, the first time I submitted it, I was just trying to make it in compliance and draw out actually getting the permit, thinking I was getting the money. And so that's why the lot is up for sale, so that somebody else that has the money can build. But, I'm kind of in
And I don't want,
22
and I
at
don't
this
want
point.
this to get lost in it completely, but I do see there's a huge improvement with the condition of the property with, you taking care of the overgrowth and everything as well. What I'm trying to do is consider some sort of scenario that will allow some action to be taken on the application front, understanding that the likelihood of you obtaining approval on it within 60 days, I mean, that's basically an impossibility.
It's not.
I will say you probably need to get with your engineer as soon as possible. Push them on it. I understand finances are always going to be a concern, but regardless of what happens with the buyer, that just needs to be taken care of. When I'm going to, let me see, what's the best way to do this? When you talk to your engineer right now, did they give you a timeline or anything for it to be completed?
No.
Have they given you a quote, an estimate, anything?
I have my dates wrong, so I thought the hearing was actually tomorrow, and he actually called while I was sitting here, but I couldn't talk to him. So I don't know what he was gonna tell me, but he has the trusses and he has the plans, and he was supposed to give me a timeline, but he hasn't given me anything as of yet. And I just got with him last week, because it was just in the last week or so that I realized that the other people weren't gonna
But
continue.
and I know engineers are kind of on their own wavelength, but the plans wouldn't have changed too dramatically since the last time you submitted an application, right? It would just certainly be a recertification. It shouldn't.
He's not the engineer that drew the plans. The engineer that drew the plans apparently does not want to recert. I don't know. I was told to go to a different engineer, so I'm kind of starting over from new. So, and that was from the person I got the plans from.
Got it.
So I'm basically starting over from the beginning with all new plans. And he doesn't like the person that drew them, and so that's another problem, because he's basically saying that he's gonna have to redo the whole thing.
Magistrate, I have two questions for Officer Wright, if I may.
Yes, please.
Officer Wright, could you please restate when the 2023 case was started? And if it was, just confirm that it was the same exact site? And it was the fill dirt being added to this property?
I don't have the date that the original case started. I do have the initial hearing for the magistrate case was April of 2023. To the best of my recollection, it was a 2022 case.
And what was the violation at that time?
It was section 34-10, and I can't, there was a second one also for alteration of the permit, or of the site.
And that case was closed?
That was put into compliance by the magistrate due to the fact that the applicant had submitted, and that she was also submitting for a variance, and was told at that time a variance could take up to 6 months to complete the permit process and hearing process. So at the previous magistrate put it into compliance to give the applicant time to go through that whole permitting process.
And what would be required of you in order to obtain compliance with the removal of the fill on the site? What would you need to see by what would the respondent need to do in order to achieve compliance through removal of that fill?
I mean, removing the I believe it was 8 loads of dirt, and then reseed it.
Okay, those are my questions. Thank you.
Right. I'm going to go ahead and make an order. I've accepted and considered documentary evidence, including photos and sworn testimony relating to this matter from city staff. I find that respondent TPK Investments LLC is the owner of the property with the address of 2700 LaGrange Road, Titusville, Florida, 32796. I find that all required notices were provided in accordance with Chapter 163, Florida Statutes and City Code, and notice was met for this hearing. Based on the evidence presented, I find that violation of section, let me get that, section 34-10, regarding site permit requirement exists upon the property, and respondents were given a reasonable amount of time to correct the violations prior to hearing, but have either failed or refused to do so. The corrective action for these violations is either to obtain a site development permit or otherwise remove the fill dirt that is upon the property. Additionally, I find that the city has incurred costs in the amount of $234.19. Such amounts shall be included with this order. Respondent shall be given until, I'm going to deviate a little bit from the recommendations. The respondent shall be given until April 11, 2025 to submit a permit application. Respondent shall thereafter move forward with getting that permit obtained and situated, taking all reasonable efforts to do so. Respondents shall be responsible for notifying code enforcement officer of the submission of the application and all the and keeping the enforcement officer notified of all the efforts that she or it is taking to obtain the permit. The code enforcement officer will confirm the status of that application. I'm going to say that I don't know how to word this exactly, but it needs to be, I want to set an outside time date for it to be obtained.
Before you move on to that, could you also include in the paragraph on April 11th or in the alternative to remove the fill dirt?
Oh, right, yes. April 11th to submit the application and or remove the fill dirt, you're right. And I'm going to say that assuming that the application is submitted by April 11th, which I know presents a challenge for you, but I want to hold some type of date to it. Assuming that it's submitted, I do want the permit to be obtained within 6 months from today's date. If it is not obtained and the code enforcement officer not notified, then a fine will be entered in the amount of $100 per day, which will date back to the original April 11th date. Further and future violations of this same section shall be classified as a repeat violation. A certified order may be recorded in the public records of Brevard County. It is so ordered. Now, for your part, obviously, this is not going to create a lien just yet. So if you're able to work with your buyer, that's not going to come up with a lien. Regardless of who buys it, they're going to be responsible for obtaining it. So that's just what it is at this point. Thank you. All right, let's go ahead and move on. I believe now we're at 25-15, right?
We are.
All right, 25-15, Simoez Property Group. Go ahead, Mr. or Fire Inspector Kyle Mack.
Indeed. All righty. So, first off, I have the exhibits for you: the notice of hearing, affidavit, the notice of hearing itself, proof of mailing, notice of violations, and the cost recovery.
Thank you, sir.
So, we have case 25-15. It's going to be the respondent of Simoez Property Group LLC, violation address of 1245 Grumman Place, Titusville, Florida, 32780. The mail-to address was 457 Montreal Avenue, Suite A in Melbourne, Florida, 32935. The violation is of Titusville Code of Ordinance, Section 3-13, which is response to alarms, corrective actions, and reports required. There we go. So the initial inspection in this case was an invoice for a false fire alarm. Invoice was initially sent on 12/3 of 2024. With a date given to comply on or before January 3rd of 25. Notice to respondent was October 3rd of, wait a minute, initial inspection. Something, I messed that one up for some of those dates there, but.
Notice of hearings, question marks?
1 second. That one doesn't make sense, but we'll circle back. So, oh, actually, it's because I didn't upload the one I fixed. My mistake. So the notice of hearing was actually done, it says on there, I believe that was the 122?
Yeah, I have the affidavit right here. Yep.
Yeah. Give me 1 second. I actually have the fixed one on here, I believe. So I can at least get the correct dates for you, and then we can get you the updated copy of the PowerPoint. There it is. So while that's opening, I'll continue on. We'll come back to the dates in just a moment. So those were mailed. The certified mail was on 1/7/2025, and we did not seem to get anything signed by the agent, and I've had no contact with the owner of the property. For the narrative of the violation, there were several fire false alarms that have occurred at this location for a total of 6. For a total of $1,740 in unpaid fire false alarm fees. So far, no attempt has been made to pay the fire false alarm fees to date. Conclusion of facts, it was Titusville Code of Ordinance Section 3-13, response to alarms, corrective actions, and report required. So to address the issue, they just need to contact the fire department to pay the fire false alarm fees. For the recommendation, I would ask that you order the respondent to correct the violation on or before 3/10/25, and that they, again, just need to contact us to make the payment. Order the respondent to be assessed administrative costs in the amount of $128.53, and if they do not come into compliance by 3/10, a fine of $50 per violation per day should be imposed. And then, of course, they can contact me at my phone number there if they have any questions or would like to ask about the violations. And it looks like I just uploaded the wrong version of the PowerPoint on here, so that was my mistake. But I will update that, and we can get you a correct copy of the PowerPoint for the dates.
All right. Sounds good. All right. I've accepted and considered documentary evidence, including photos and sworn testimony relating to this matter from city staff. I find that respondent Simois Property Group LLC is the owner of property with the address of 1245 Grumman Place, Titusville, Florida 32780. I find that all required notices were provided in accordance with Chapter 163 Florida Statute and City Code, and notice was met for this hearing. Based on the evidence provided, I find that violations of Section 3-13 of the City Code regarding response to alarms, fire alarms exist upon the property, and respondents were given a reasonable amount of time to pay the outstanding fines or fees to correct the violation prior to the hearing. The corrective action, as stated, was to pay the fire department, what was it, $1,740?
I believe so, yes.
Yeah. Additionally, I find the city has incurred costs in the amount of $128.53. Such amounts shall be included with this order. Can you put the recommendations back on there so I can get the exact date? Was it March 10th?
March 10th, yes, 3/10/25.
Respondent shall be given until March 10th to correct the violation. Respondent shall be responsible for notifying, I guess, not necessarily code enforcement officer or the fire marshal of completion of such corrections, who shall then confirm the status of the violation. If respondent fails to pay the $1,740 by March 10th, 2025, I will recommend a fine be entered in the amount of double of that amount, which is $3,480 just as a flat fine. Further, in future violations of the same section shall be classified as a repeat violation. A certified order may be recorded in the public records of Brevard County. It is so ordered. Thank you.
Sir,
Yep.
I would, I was unaware of the dollar amount of the fire fee on that one. What is one time? What is that's for 6. What is the one-time amount for a fire alarm fee?
$290.
So 6 times, yeah.
So they have 6.
I understand it's 6. I don't know if we can impose that high of a
Okay.
one-time fee. I don't know if we are capped at 250. But I do recommend that we do the one-time fee. And I would suggest that we impose $250 in addition to the fee if it's not paid by the March 10th date, rather than doubling
Okay.
it.
So the 1,740 plus 250?
Yes, sir.
Okay.
Plus the cost.
I just thought our fine fire marshals needed more money, but
I mean, I'll
you're
take
trying to
whatever
take
I
it out
can
of their
get,
pocket. Yeah, that's fine. 1,740, so that'd be 1950 or 1990, right? Yeah.
Plus the cost, which
Plus the
were,
cost,
in which
yeah.
amount?
Okay.
120.
So, Ms. Mickey, if you can revise that. So instead of doubling the 1740, we're going to add 250 to the 1740, and then of course the cost of collection. And so if you guys are under budget for this year, please talk to Ms. Chelsea
Yes,
about that.
she will be added to our Christmas card.
Thank you all. All right. So moving on. 25-18, correct?
Yes.
All right.
So this will be 25-18. My PowerPoint. I have the affidavit with the notice of hearing, notice of violation, the notices of hearing and violation, as well as the certified mailing and the cost recovery.
Thanks.
So for this, case number 25-18 is going to be Applewood Apartments LLC with a violation address of 4747 South Washington Avenue in Titusville, Florida, 32780. Mail to address of Applewood Apartments LLC, 5713 Grand Avenue, Suite B, Duluth, Minnesota, 55807. Right now we have 2 open violations. The first one is NFPA 1.7.12, which is permit required, and NFPA 1 10.18.5.1, which is combustible storage in equipment rooms. So my dates are correct on this one. So initial inspection was back at August 9th of 2024. At this time, the location was given notice that a permit was required for the unpermitted installation of a new fire alarm system at the condo. The original date given to comply was 8/16 of 24. Notice to respondent was 8/19 of 24, mailed certified, and we did not get one for that, a return. The notice of hearing was 1/22/25. It was posted at City Hall and on the property where the violation exists. Certified mail was 1/7/25, delivered and signed for on 1/15/25 by the agent. I have had no contact with when I say the owner, in this case, it's the HOA. I have been contacted by call it the real estate representative of the HOA. He informed me that they were going to clean out the equipment room and that the maintenance supervisor would contact me when that was done. I have not received any contact from him, and I have had no contact about the fire alarm permit itself. So the narrative, location had a fire alarm system that was damaged by severe weather. It's required them to completely replace the existing fire alarm system, and because of that, they needed to bring it up to current code requirements. It was discovered actually during a crew walkthrough, and they called me out to take a look at it. While we were there, notified HOA representatives that they would have to either repair the system in kind so that it would be able to stay, or if they got a completely new system, they would have to bring it up to current code. So, I don't know, about a month or 2 later, we were notified by the previous fire alarm contractor that was servicing the original system, and they informed us that a new fire alarm had been installed. It was installed without permits and with no testing, and because of this, the system needs to be permitted and tested to ensure proper operation. And then, of course, there was also a large amount of storage in that same electrical equipment room, which is not permitted to be there. As a result of the reinspection, there has been no attempt to obtain the permit, and as far as I'm aware, they have not cleaned the equipment room out. For the conclusion of facts, for the permit required, they just need to obtain a fire alarm permit and follow through the permitting process. And then for the combustible storage in the equipment room, they just need to remove the combustible storage from the equipment room. For the recommendation, I would ask that they be ordered to correct the violations on or before 3/10 of '25. To correct the violation, they simply need to obtain a fire alarm permit and complete all the necessary testing to ensure that the alarm works properly, and then remove all storage from the electrical room. I would ask that they be assessed administrative costs in the amount of $110.92, and if they do not comply by March 10th of '25, a fine of $250 per day for the fire alarm system due to the life safety component of having a fire alarm system that does not operate as intended, and only $50 per day for the storage due to being a lower priority violation. I would ask that those be imposed per day until those individual violations are concluded. And of course, they can contact me if they have any questions, comments, or concerns.
How long does it usually take to get the permit?
For the fire alarm, since it's really only the fire department that works for it, once they submit it, it takes, I don't know, a few days in the
Okay.
building department. And then once I see it, I'm the one who does the review, so I can go ahead and get it taken care of within a day or two.
Well, 30 days should be more than ample time.
I wouldn't think so. I think that would be reasonable.
Okay. All right, thank you. I've accepted and considered documentary evidence, including photos and sworn testimony relating to this matter from city staff. I find that Respondent Applewood Apartments LLC is the owner of the property with the address 4747 South Washington Avenue, Titusville, Florida 32780. I find that all required notices were provided in accordance with Chapter 163 Florida Statute and City Code, and notice was met for this hearing. Based on the evidence presented, I find that violations of sections of NFPA 1-1.7.12 regarding a fire alarm permit, and NFPA 1-10.18.5.1 regarding combustible storage exist upon the property, and respondents were given a reasonable amount of time to correct the violations prior to the hearing. Those corrective actions are to obtain a permit for the first violation, and then to remove storage from the electrical room for the other violation. Additionally, I find the city has incurred costs in the amount of $110.92. Such amounts shall be included with this order. Respondents shall be given until March 10th, 2025 to correct the violations. Respondents shall be responsible for notifying the code enforcement officer of completion of such corrections, who shall then confirm the status of the violation. If respondent fails to correct the violation by March 10th, 2025, a fine will be entered in the amount of $250 per day for the permit violation, and an additional $50 per day for the combustible storage violation, which will accrue until the violation comes into compliance. Further and future violations of the same section shall be classified as repeat violation. A certified order may be recorded in the public records of Brevard County. It is so ordered. Thank you. All right, let's go on to 25-20.
Me again. All righty, so 25-20, I have the affidavit for the notice of hearing, the affidavit for the notice of violation and the notice of violation, as well as the certified mailing and the cost recovery. So for this, we have 25-20, which is MBA BJB Holdings. It's a tongue twister. Family LP. Violation address is going to be 2825 Garden Street, Unit 2 in Titusville, Florida, and that's 32780, I think. And then the mail to address is going to be 101 Southeast 6th Avenue, Suite C in Delray Beach, Florida, 33483. For the two violations at this location, it's going to be Titusville Code of Ordinance Section 11-31, which is business tax receipt required, and Section 9-12, which is occupancy inspection fee. For the case summary, the initial inspection was back in April of 2024 on the 12th. another little oops on that one. It was originally the annual fire inspection, not the false alarm fee. The date given to comply was 4/26 of '24 for the standard 14 days. Notice of respondent was on 4/12, which was mailed, certified. We did not receive any sign for that. Notice of hearing was 1/22 of '25, posted at City Hall and on the property where the violation exists, and the certified mailing was 1/7 of '25 and was not signed for. For the owner, we have been in contact with either the owner or a representative of the owner. They contacted community development and said that they intended on getting a business tax receipt and renewing all of that. It simply has expired and they never renewed it. Has not yet happened. I checked on Friday and it had not been applied for or extended, and our system was unfortunately down today, so I was not able to check this morning. But for the violation during the annual fire inspection, it was among a couple other violations that have otherwise been corrected. It was found the location did not have a valid business tax receipt, and due to that had not paid the occupancy inspection fee. The business was notified several times, and after many months, as I said, the current owner advised they were going to renew the license, but this has not occurred. Results of the reinspection, no attempt so far to renew the license or pay the inspection fee has occurred. So conclusion of facts for section 11-31, they just need to contact community development to renew the business tax receipt. And for section 9-12, same thing, the inspection fee is part of the business tax receipt. So if they renew their business tax receipt, the inspection fee will be paid and that violation will be closed. So for the recommendation, I would ask that the respondents be ordered to correct the violation on or before 3/10 of '25, that they contact community development to renew the BTR and pay the inspection fee, that they be assessed administrative costs in the amount of $163.75, and that if they do not comply by 3/10 of '25, a fine of $50 per day per violation should be imposed for each day the violation continues. And if they have any questions, comments, or concerns, they can reach out, and I will do my best to assist them.
Do you know what kind of business it is?
Smartphone sales.
Okay. All right. I have accepted and considered documentary evidence, including photos and sworn testimony relating to this matter from city staff. I find that respondent MBA BJB Holdings Family LP is the owner of the property with the address 2825 Garden Street, Unit 2, Titusville, Florida 32796. Find that all required notices were provided in accordance with Chapter 163, Florida Statute and City Code, and notice was met for this hearing. Based on the evidence presented, I find that violations of Titusville City Ordinance 11-31 regarding business tax receipt and Section 9-12 for the occupancy inspection fee exist upon the property, and respondents were given a reasonable amount of time to correct the violations prior to the hearing. But if I either failed or refused to do so, the corrective actions for these violations shall be to contact community development and renew their business tax receipt, and also to pay the inspection fee. Additionally, I find that the city has incurred costs in the amount of $163.75. Such amounts shall be included with this order. Respondent shall be given until March 10th, 2025 to correct the violations. Respondent shall be responsible for notifying the code enforcement of completion of such corrections, who shall then confirm the status of the violation. If respondent fails to correct the violation by March 10th, 2025, a fine will be entered in the amount of $50 per day until the violation comes into compliance. Further and future violations shall be of the same section shall be classified as repeat violation. A certified order may be recorded in the public records of Brevard County. It is so ordered. Good?
All right, thank you.
That's it?
Yes, sir.
All right. Do we have a manager's report?
No, sir, no report.
That's it? All right. That's anticlimactic way to end it. I'll adjourn this, this month's meeting. Thank you.